The High Court in London has, at least for now, blocked the extradition of the Wikileaks founder Julian Assange to the United States. It granted him permission to appeal against the order that he should stand trial for leaking military secrets which endangered lives. The court had previously sought assurances from Washington that Mr Assange's free speech would be protected and that he would not face the death penalty if convicted. During the hearing, Mr Assange's lawyer said US promises given so far were inadequate. Julian Assange has spent more than a decade resisting deportation and facing the espionage charges. Our legal correspondent Dominic Casciani has been telling us about the key points from today's ruling at the High Court.
Yeah, I think the key point, Anita, is it's very, very noisy down here because hundreds of people have turned up to support Julian Assange and to show solidarity with him because they believe he's been appallingly unjustly treated over the last few years since 2019 when he's fought this US extradition. And there has been, I think in fairness, a sense of legal inevitability about the direction this was going in a succession of court rulings. But this morning, two senior judges here at the High Court effectively put the legal blockers on the whole thing, for now at least, because they accepted a very narrow argument that Julian Assange says he has. That in effect, when he, as part of the Wikileaks organisation in 2010, leaked US military secrets, he did so to expose war crimes, and therefore he had a right to free speech in doing that under the US Constitution, and therefore cannot be prosecuted for doing so. Now, the US says it's given assurances that this is not the type of a case where free speech comes into play. But this has not satisfied the judges here in London. And they've said, well, we want to have a full appeal on this point and actually really try to unpick this. The other point of assurances from the US that Julian Assange will not face the death penalty, that has been accepted by his team now. That is no longer an issue. It fundamentally comes down to this question of whether or not he, if he went on trial in the United States, can say, I have a defence of speaking out freely in order to expose war crimes, and that should be heard in my trial. And that's why this case is going away for a few months. I'm just looking over to my right at the moment, Anita, and Stella Assange, Julian's wife, has now started speaking. She was in court for this judgment. The lawyers around her were absolutely jubilant that they'd got it through to this final appeal stage. And a few minutes ago, she came outside. She said that they want the US to drop this case once and for all because this is a waste of time, it's an unjust case, and they want Julian Assange out of the prison where he's been held and to be a free man.
Dominic Casciani. And let's talk now to the former head of extradition at the Crown Prosecution Service, Nick Vamos. Nick, thank you very much for joining us today. And I want to begin by getting your assessment of what happened in court today.
Well, Dominic Casciani summed it up very well. I think the key distinction that the court made was between whether Mr Assange would be denied his First Amendment rights because they don't apply to this particular offence and set of facts, that would be fine, or whether he'd been denied them because he's a non-US national. And that was the point. So the bar to extradition is whether he would be discriminated against on the grounds of his nationality. And what the US government have said is that it's actually an undecided point of US law whether non-US nationals are entitled to seek the protection of the First Amendment, plead freedom of speech. And so the US government can't say whether Mr Assange will have that protection or not. It's an argument he would have to make to the US court. So the English court has said, well, that's not a good enough assurance for us, so it has to now go off for a full appeal.
Mr Assange's legal proceedings have spanned about a decade now, so he now appeals, or his lawyers lodge an appeal for him. Take us through what that process could look like.
Well, these ones haven't actually lasted a decade. So he was taken out of the Ecuadorian embassy several years ago. That was the first time the US issued an extradition request. Prior to that, it was a Swedish request, and of course he then hid in the embassy for several years. But we are getting to the end of what's been a very long saga with new chapters being added all the time. So he's been given leave to appeal on one ground, and as Dominic said, it's a very narrow ground, it's quite technical. All of the other arguments about political motivation and CIA death squads and whether this is journalism or otherwise, those can't be revived. So he just has this one argument, and of course it doesn't apply to the charge of hacking, because he's charged both with publishing the material, and that's where he may say that he's protected by the First Amendment, but also assisting Chelsea Manning to hack it, which has got nothing to do with freedom of speech. So even if he wins on this one ground, I suspect he could still be extradited on the hacking offences, Although, of course, at that point, the US government may decide it's not worth it. And this case is so unpredictable, I wouldn't like to say.
OK, Nick Vamos, thank you for your thoughts on that.